Hello and welcome. I will be reading the most recent filing from the Karen Reed defense team. They submitted their reply brief to the Supreme Court last Wednesday, a week ago, October 23rd, 2024. The document reads, Commonwealth Appellee versus Karen Reed, Defendant Appellant, on appeal from reservation and report of GLC 211 subsection 3 petition. Reply brief of appellant Karen Reed, and it lists her attorneys, Martin G. Weinberg, Michael Pabian, Alan J. Jackson, and David R. Yannetti. It is dated October 23rd, 2024. Table of contents, table of authorities, introduction. Ms. Reed's motion to dismiss is predicated upon post-trial statements of 5 jurors, in parentheses, 4 directly and 1 indirectly, that the jury reached a final unanimous decision to acquit her of second-degree murder. In the usual course, that verdict would have been announced in open court, and re-prosecution for that charge would be constitutionally prohibited. Here, however, the trial court failed to inquire, pursuant to Massachusetts Rules of Criminal Procedure 27B, regarding the existence of any partial verdicts, and for that reason, the jury acquittal was not announced. So far they're saying because Rule 27B was not followed, the jury acquittal was not announced. Continuing, the Commonwealth's argument that this court should defer to the trial judge regarding the necessity of a mistrial seeks to inappropriately bypass the clear prerequisites that have been in place for almost 4 decades, that before the declaration of a mistrial, in quotations, 1, counsel must be given full opportunity to be heard, and 2, the trial judge must give careful consideration to alternatives to a mistrial, end quote, provides the case law. Here, there is no indication that the court gave any consideration to alternatives, most notably inquiry regarding partial verdicts, and counsel was not given a full opportunity to be heard. The court never asked for counsel's views or even mentioned the word mistrial before sua sponte declaring one in open court. And for those who have not watched my previous videos, the term sua sponte is a legal term, and all it means is on the court's own decision. Like it's a motion or an order that the judge makes on their own without being prompted by either the defense or the prosecution. It also applies to civil cases, family court cases as well. So sua sponte is an order or a motion that the judge makes him or herself in court without being prompted by either side, or without either side filing a motion in order to acquire the order, if that makes sense. And as I've said, arguing these court filings, observing these court filings between the prosecution, the defense, and Judge Beverly Cannoni, I agree that Judge Beverly Cannoni announced and declared the mistrial sua sponte. Judge Beverly Cannoni declared the mistrial completely and entirely on her own terms. Continuing to read, the Commonwealth's attempt to shift blame for these omissions to Miss Reed and her counsel utterly neglects the black-letter law that the Commonwealth, as the party seeking retrial, bears the exclusive burden of establishing manifest necessity. And that's really good for the defense to word it like this. I'm going to read that sentence again. The Commonwealth's attempt to shift blame for these omissions to Miss Reed and her counsel. It's just spot on. It's such an accurate description of what happened. The Commonwealth, the prosecution, and Judge Beverly Cannoni herself in her own court filing continues to shift blame. And if you guys don't know, that's like an abusive tactic. You know, if any of you study narcissism, when someone shifts blame or is blame shifting, they are removing all personal responsibility from themselves and placing it onto you, even when they are actually at fault, or even when they are responsible for what happened. So the prosecution / the Commonwealth and Judge Beverly Cannoni have both overtly in their court filings, which again are publicly available. This is all documented. The prosecution and Judge Beverly Cannoni continue to shift blame back to Karen Reed when in fact nowhere in history is a mistrial dictated by a defense team. The defense team in any criminal case does not dictate when or if a mistrial is declared. The declaration of a mistrial falls solely on the prosecution and the judge. Okay? It's ridiculous how far the prosecution and Judge Bev have gone to remove all personal responsibility from themselves, despite all the efforts of integrity. Like the only people with any integrity in this case is the defense team. And I guess the ACLUM. Like the defense team has continued to fight the good fight while the prosecution and the judge continue to obfuscate, continue to omit, continue to pretend that everything's fine, and the only ones who made a mistake was the defense. Just a really bizarre case, but it's bizarre in that they don't even care that all of this shit is available publicly. Again, they don't even care that the ACLUM reached out to the Supreme Court in defense of Karen Reed. Like, the overt corruption in this case is over the top. Okay, continuing to read. Okay, right here. The defense independently maintains that a jury's final, unanimous agreement that Miss Reed is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontradicted post-trial affidavits entitle her to a judicial inquiry on this issue. There is no precedent for the Commonwealth's contention that the lack of formal announcement alone can overcome the defendant's fundamental right not to be tried a second time for a murder that a jury already determined she did not commit. So I'm going to read that last one again. There is no precedent for the Commonwealth's contention that the lack of formal announcement alone can overcome the defendant's fundamental right not to be tried a second time for a murder that a jury already determined she did not commit. So the defense is saying, like, there's actually no case law. There's nothing to refer to with respect to the Commonwealth's contention that the lack of announcing the verdicts in open court alone overrides Karen Reed's fundamental right to not be tried a second time. And if you guys watched my video about the amicus brief that the ACLUM filed to the Supreme Court, the ACLUM provides case law that, in fact, not announcing the verdict in open court has nothing to do with double jeopardy. Double jeopardy clause applies as soon as the jury is sworn in. it's like the verdict, announcing the verdict in open court or not announcing the verdict in open court has nothing to do with a person's protections against double jeopardy. So both the ACLUM and the defense are arguing that the Commonwealth and Judge Beverly Cannoni are out of bounds. They're making up their own rules here, and they're ignoring the rules of criminal procedure, and they're ignoring case law that actually applies. Okay, continuing argument. Number 1, the Commonwealth did not satisfy its burden of establishing manifest necessity. As noted in Ms. Reed's opening brief, quote, "This court reviews determinations regarding double jeopardy de novo," end quote. Provides the case law. Quote, "Determination regarding manifest necessity for abuse of discretion," end quote. Such, quote, "appellate deference will be accorded only if the record reflects that the trial judge gave reasoned consideration to the various available alternatives," provides case law. Quote, "If the record reveals that the trial judge has failed to exercise the sound discretion entrusted to him, the reason for deference by an appellate court disappears," end quote. Here, it is not, quote, "clear from the record that the judge," end quote, "gave, quote, careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding," end quote, and accordingly, the abuse of discretion standard does not apply, provides case law. The Commonwealth's heavy reliance upon purported discretion without acknowledging the foregoing principles represents an attempt to bypass the two guideposts that have governed the court's manifest necessity jurisprudence for nearly 40 years. Quote, "1, counsel must be given full opportunity to be heard, and 2, the judge must give careful consideration to alternatives to a mistrial," end quote, provides the case law. So I'm just going to stop it there to summarize what's being said so far. The defense is continuing to press the argument that the Commonwealth, the prosecution, is trying to bypass the prerequisites for declaring a mistrial. And 2 of those prerequisites are that counsel, aka the lawyers, both sides, the defense and the prosecution, were supposed to be given a full opportunity to be heard before Judge Beverly Cannoni declared a mistrial. And number 2, the trial judge, aka Beverly Cannoni, was supposed to give careful consideration to alternatives to a mistrial. So she failed twice, guys. Those are the 2 long-standing prerequisites for declaring a mistrial in the state of Massachusetts, and Judge Beverly Cannoni failed to follow both. So she not only failed to follow the case law, she also failed to follow the rules of criminal procedure. Okay? Guys, this is real. This is for real. The corruption is real. Continuing. Contrary to the Commonwealth's suggestion, resolution of these issues does not depend upon any, quote, credibility determination, end quote, provides case law. Rather, the court must simply determine whether the record in this case satisfies the applicable standard as construed by its precedents. Nothing in the Commonwealth brief justifies the trial court's failure to consider the alternative of inquiring regarding the existence of any partial verdicts pursuant to Rule 27B. So just to repeat what the first sentence is saying, the defense is saying that in the Commonwealth's brief, which I made a video about, I did not read the entire brief because I was getting too triggered, but in the prosecution's brief, which they filed in response to the defense's motion to dismiss via the Supreme Court, the defense here, in their reply brief, they are saying that the prosecution, in their court filing, provided nothing that justifies the court's, Judge Beverly Cannoni's, failure to consider the alternative of inquiring regarding the existence the existence of any partial verdicts pursuant to Rule 27B. So the defense is saying that the prosecution, in their most recent brief that they filed with the Supreme Court, they did not provide anything. They did not provide a response to the fact, to the documented fact that Judge Bev did not follow Rule 27B, which would have allowed the court to hear about any partial verdicts. Okay, continuing. While the timing of whether to accept a partial verdict is ordinarily discretionary, Rule 27B requires the trial court to accept such partial verdicts before declaring a mistrial. And if you follow me long enough, you know that I have stressed Rule 27B because, again, there were multiple charges against Karen Reed. And in the state of Massachusetts, when there are multiple charges against a defendant, the trial court judge, Judge Beverly Cannoni, is supposed to follow Rule 27B in order to make sure that the court and the world watching the case knows what the result was for each charge. When there are multiple charges, the defendant has a right to know what the verdict is for each charge. And that's what Rule 27B provides. It's a safeguard. And Judge Beverly Cannoni did not follow that safeguard. And they cite Rule 27B, the reporter's notes, quote, "This rule provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon." And again, I've stressed I've stressed that over and over again. She's allowed to declare a mistrial, but she was supposed to first mandate that the jury give her verdicts. And again, she did not do that. She did not do a damn thing. She declared a mistrial sua sponte, on her own terms. Continuing, none of the cases cited by the Commonwealth is to the contrary. In 2 of those cases, the jury expressly indicated it was deadlocked on all counts, provides the case law. Note, quote, stated that the jury could not reach a unanimous verdict as to either, end quote, of 2 indictments, provides the case law. In parentheses, jury said, quote, further deliberation will not yield a unanimous verdict on any indictments, end quote, and defense counsel, having been provided an opportunity to respond, agreed that the jury was at an impasse on all indictments and said he had no objection to mistrial. In these circumstances, inquiry regarding partial verdicts is understandably not required, but here the jury never specified or was asked to specify on which counts it had reached an impasse, nor had counsel consented, as in Daniels, to a mistrial, provides case law. Is also readily distinguishable. There, state law prohibited a partial acquittal for offenses included within a single charge. Here, in contrast, it is clear that Rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments, provides a case law. A juvenile like Bluford involved lesser included offenses within a single count and are thus inapposite as to whether the court should have considered the possibility of partial verdicts on separate counts under Rule 27B. As set forth above, because the record reflects no consideration of alternatives to a mistrial, this court should not defer to the trial court's construction of the jury notes. In any event, the notes were readily susceptible to a reading consistent with the post-trial juror statements. The first note, stating that the jury was, quote, unable to reach a unanimous verdict, did not preclude the existence of final unanimous agreement on some but not all counts, particularly in the context of the court's prior instruction to, quote, continue deliberating until you have reached a final verdict on each charge. Good job. Good job. So just to summarize what the defense is saying here, in the jury's first note, quote, they were unable to reach a unanimous verdict, but it did not preclude the existence of final unanimous agreement on some but not all counts, particularly in the context of the court's prior instruction to, quote, continue deliberating until you have reached a final verdict on each charge. So it is documented that during the Karen Reed trial, the jury were given the instruction to continue deliberating until you have reached a final verdict on each charge. It's specific, on each charge. And yet the jury notes were never specific as to which charges they could not reach a unanimous verdict. The jury notes not once did any of the jury notes during deliberations, not once did any of the jury notes specify which of the verdicts, which of the charges they were at an impasse. The jury notes were vague, and no one knew which charge they were referring to. The jury notes were almost like generalizations. We're at an impasse. We're not able to reach a unanimous verdict, but completely omitting, completely leaving out any specificity as to which charge. And again, for Karen Reed, there were 3 charges. And again, guys, this isn't on the defense. This is not the defense's fault. This is actually the prosecution and Judge Beverly Cannoni's fault. They were supposed to be careful and cautious and specify, make it clear to the court and to the record which charges the impasse applied to. And that never happened. It remained an ambiguous situation. And Judge Beverly Cannoni declared a mistrial despite the ambiguity of the jury notes. Continuing, the Commonwealth states that the defense's reading of the notes, quote, is not the more natural and straightforward, end quote, but it does not explain why the defendant's alternative, in parentheses, and in retrospect correct reading is not a reasonable alternative that the court completely failed to consider. Yeah, among many others, right? Like just following the rules of criminal procedure would have provided a sufficient alternative to declaring a mistrial. But not one single alternative was provided before the mistrial was declared. Continuing, the Commonwealth cites no authority for its contention that it is necessarily coercive for a court to inquire regarding the possibility of partial verdicts on separate indictments. So what that sentence, what the sentence is saying, I will read it again. The Commonwealth cites no authority for its contention that it is necessarily coercive for a court to inquire regarding the possibility of partial verdicts on separate indictments. So the defense is saying that in the prosecution's reply brief that they again submitted to the Supreme Court, they do not provide case law. They don't provide a rule of criminal procedure. They cite no authority for their stance that it would be coercive for the court to have a post-trial inquiry as to whether or not there were partial verdicts on any of the charges. So you see, both the prosecution and Judge Bev want to keep pushing the narrative that it would be unethical to have a post-trial inquiry, and yet they provide no case law and no rule of criminal procedure. No court rule, no case law as to why it is considered coercive for them to have a post-trial inquiry. And if you guys remember, the ACLUM in their amicus brief, which again they filed in this case in the Supreme Court on behalf of Karen Reed, they also they also kind of blow the prosecution and Judge Bev Cannoni's arguments out the window, in that they say actually post-trial inquiries regarding jury verdicts are a regular thing in the state of Massachusetts. It's not new case law. It's not unheard of. And they provided case law after case law after case law in the state of Massachusetts in which post-trial inquiries happen. It's not abnormal. Again, the prosecution and Judge Bev have tried to like drive this somewhere it doesn't need to go. They've tried to they're controlling everything is what they're doing, and they're not following any actual case law or any actual rules of criminal procedure. They're driving this entire thing on their own, completely like bulldozing through prerequisites, bulldozing through things that again, according to ACLUM and the prosecution, have been going on in Massachusetts for decades. The prosecution is acting like they just started the job yesterday, like they haven't been attorneys for decades. And so too is Judge Bev. She too is acting like she just became a judge and she's new to the job and she doesn't actually know what to do when there are multiple charges against a defendant. Both the judge and the prosecution are playing dumb. Continuing to read. Indeed, the case law holds that such inquiry is not coercive, provides case law. The Commonwealth claims Foster and LaFontaine are, quote, inapposite because neither of those juries reported being deadlocked, end quote. But Roth cited both those cases in the context of a deadlock for the proposition that partial verdicts are permissible when there are separate indictments rather than a single indictment. Provides case law, in parentheses, acknowledging authority to accept partial verdicts from jury deadlocked on one but not all counts. The trial court's failure to consider inquiry regarding partial verdicts cannot be excused based on speculation that defense counsel may have objected to such inquiry when in fact defense counsel never did. The court could and should have raised the issue with the parties and considered their respective views. This is precisely what the two-pronged Stewart-Taylor test requires. Defense counsel's earlier argument regarding the propriety of the count 2 verdict form, which the trial court ultimately agreed with, did not excuse the judge from complying with this court's manifest necessity jurisprudence. Yeah, so just really thorough arguments from the defense here. They're covering everything. They're taking everything that the prosecution has argued in their so-called rebuttal, which, if you remember my video, it was not a rebuttal. It was not a response. The prosecution did not actually respond to the defense like they are required to do. The prosecution provided rebuttals and new arguments separate and apart from the defense. And as I've said, it was really strange for me to read it. I've never seen that happen, guys. Anyway, I'm gonna keep reading. Okay, continuing to read. Another alternative to a mistrial was to poll the jury. The record reflects no consideration of that alternative either. Excellent. The defense is being extremely thorough here. Really well done. They are providing example after example of the judge, the court, not providing alternatives to the mistrial. They're also providing options that the judge could have utilized and she failed to. Just really good stuff. Continuing. The Commonwealth follows the trial court's lead in utterly failing to acknowledge the clear and long-lasting case law, placing the burden of establishing manifest necessity squarely and exclusively on the Commonwealth, the party seeking retrial. And that's good for the defense to point that out. They're saying here the Commonwealth / the prosecution followed Judge Beverly Cannoni's lead in utterly failing to acknowledge the clear and long-standing case law, placing the burden of establishing manifest necessity squarely and exclusively on the prosecution. So it's documented even here, guys. I have said that the prosecution and Judge Bev are defending each other. They're all about protecting each other and protecting one another's actions and putting the blame on the defense when the defense didn't actually do anything wrong. And it's really good on the defense to group them together. They grouped the Commonwealth / prosecution in with the trial courts, aka Judge Bev. Okay, the prosecution and Judge Bev are following one another in utterly failing to acknowledge long-standing case law. And again, I made that determination on my own. So yeah, it's so clear here. It's even clearer here coming from the defense. Continuing to read. Indeed, the Commonwealth brief fails to so much as mention the applicable burden or to cite Commonwealth versus Nicole provides case law, which the defense brief discussed at length on this issue. The trial court's misallocation of the burden constitutes legal error requiring reversal. And that's a powerful sentence. I will read it again. The trial court's misallocation of the burden constitutes legal error requiring reversal. So they're saying that the Judge Beverly Cannoni's failure to ensure that the prosecution met the burden of manifest necessity before declaring a mistrial means that Judge Beverly Cannoni erred, and her error requires a reversal. The defense is asking the Supreme Court to reverse Judge Beverly Cannoni's error. Continuing. The record is similarly lacking on the second Stewart-Taylor requirement, the opportunity to be heard. The Commonwealth does not dispute, because it cannot, that the trial court never asked counsel for their views regarding a mistrial. So that's another powerful sentence. The prosecution does not dispute, because the prosecution cannot dispute that the trial court never asked the lawyers for their views regarding the declaration of a mistrial. It's on the record. Okay, everything that happened during trial was recorded. As are most trials, they usually end up with a transcript, right? Everything is summarized in a transcript. That transcript is a legal record of what happened. It's a legal recording of what happened during trial. And nowhere in that recording is there evidence, is there proof that that Judge Beverly Cannoni asked the defense or the prosecution for any comment before she declared a mistrial. So the Commonwealth, the prosecution, did not dispute that they were not given an opportunity to be heard, because they can't dispute it, because it's documented in the court record. Continuing. In fact, the first time the word mistrial appears in the record is when it was declared in open court. That's a solid, irrefutable sentence. It's a solid, irrefutable argument. In fact, the first time the word mistrial appears in the record is when it was declared in open court. The first time the defense and the prosecution ever knew that there was going to be a mistrial was when Judge Beverly Cannone declared a mistrial. There was no heads up that she was going to declare a mistrial. This is really good, guys. Continuing to read. The court's sua sponte action in these circumstances was aptly described as, quote, sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Continuing. The Commonwealth cites no comparable case finding the requirement of an opportunity to be heard satisfied. Video footage reinforces the suddenness of the court's action and corresponding lack of any meaningful opportunity to be heard. So right here, guys, the defense is they're being so solid and so thorough. They're not just relying on the court transcript, the legal recording of what happened during trial. They are also relying on video footage of what happened during trial. Not even the prosecution relied on the video footage to back up their arguments because they can't. It's so good, guys. I'm so proud of the defense. Continuing. Video footage reinforces the suddenness of the court's action and corresponding lack of any meaningful opportunity to be heard. At the approximately 5:47:25 mark of the video, the court took the bench and stated, quote, the jury is at an impasse, end quote. At approximately 5:47:55, a mere 30 seconds later, the jury arrived in the courtroom. The court then read the note, which had not previously been provided or read to counsel on the record. At 5:49:23, the court stated it was declaring a mistrial and immediately discharged the jury at 5:49:30, a mere 7 seconds later. Beautiful. Like, just profoundly profoundly irrefutable. Like, you don't believe us? You don't believe the transcript? Just watch the video. Look, at approximately 5:47:25, the judge sat down. Judge Beverly Cannone sat down at 5:47:25, and she said the jury is at an impasse. Okay, 5:47:25, and then at 5:47:55, 30 seconds later, the jury arrived in the courtroom. The court, aka Judge Bev, then read the note, which had not previously been provided or read to counsel. She read that note on the record. Okay? Okay. And at 5:49:23, the court stated it was declaring a mistrial. Okay? So Judge Bev Cannone between 5:47 p.m. and 5:49 p.m. declared a mistrial. She declared a mistrial at 5:49:23 p.m. and the jury were excused from the court at 5:49:30 p.m. 7 seconds after Judge Bev declared a mistrial, she said the jury to go in the back and meet her, and she'll meet them in a minute. This is the actual timeline of what happened. This is how quickly Judge Bev declared that mistrial. This is irrefutable proof that at no point between Judge Beverly Cannone saying the jury is at an impasse and Judge Beverly Cannone declaring a mistrial, at no point between those two events was the defense or the prosecution given an opportunity to be heard before she declared that mistrial. It is irrefutable, guys. Continuing to read. To suggest that counsel must have lodged an objection within this brief interval, or that counsel had any, much less a full opportunity to take a position or even communicate with their client, quote, underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial, provides the case law. Continuing, legal and factual context renders the trial court's action even more unexpected. Legally, trial counsel was entitled to rely on decades of case law expressly requiring a, quote, full opportunity to be heard, end quote, before declaration of a mistrial, provides case law. Factually, in response to multiple prior jury notes, in this case, the trial court had advised counsel of the contents and afforded them time, first to consider and then be heard regarding any issues raised. The trial court's deviation from that well-known and accepted practice with respect to the final note was indeed sudden and unexpected. The court should reject the Commonwealth's attempt to conflate a request for a Tui Rodriguez charge with a request for a mistrial. Yes, the defense is saying the court should reject the prosecution's attempt to conflate a Tui Rodriguez instruction with a request for a mistrial. And again, that's a valid argument because, again, the Tui Rodriguez charge is an instruction. It is not and never was an alternative to a mistrial. Continuing, as the Commonwealth acknowledges, a Tui Rodriguez charge is designed to, quote, encourage a jury to consider seriously and with an open mind the views and arguments of each member, end quote, with the ultimate goal of reaching a verdict. Provides case law. Importantly, a Tui Rodriguez instruction is not a necessary prerequisite for a mistrial. You see that, guys? Importantly, a Tui Rodriguez instruction is not actually a necessary prerequisite for a mistrial. But if you read Judge Beverly Cannoni's court filings, and if you read the prosecution's court filings, both of them swear up and down that the Tui Rodriguez instruction is an alternative to the mistrial. Both of them are lying out of their asses. They are completely and utterly wrong. Again, they are behaving like they're brand new, like they just started their jobs. Continuing. If the defense wanted a mistrial, it could have simply requested one, which it indisputably never did. Counsel was not required to affirmatively exhibit any, quote, curiosity about the extent of the jury's deadlock, end quote, until that deadlock had been firmly established. Provides case law. It was at that point, before declaring a mistrial, that the court was required to, quote, receive and record the verdicts which the jury could agree upon, end quote. And they are again citing Massachusetts Rules of Criminal Procedure, Rule 27B. Continuing. GLC 234A subsection 68C provides that if the jury reports an impasse after a Tui Rodriguez instruction, they, quote, shall not be sent out again without their own consent, end quote. The Commonwealth does not explain how this statute would, in any respect, impact the court's ability to simply ask the jury whether it had reached any partial verdicts. Precisely. Because, again, if you guys remember Judge Beverly Cannoni in her court filing, her half-assed bullshit court filing, in response to the defense's motion to dismiss, she cited the case law saying like I had to declare a mistrial because they shall not be sent out again without their own consent. I couldn't force them to keep deliberating. I had to declare a mistrial. Like, it was such bullshit. It was not a legal argument. It's not. Again, there were multiple charges against Karen Reed. She was required, Judge Bev was required to ask if there were verdicts on each and every charge. I'll keep saying it. She was playing dumb. The prosecution is playing dumb. They are playing dumb together, and they are defending one another's actions. All the while, Karen Reed's fate hangs on the line, and neither of them care because they're all psychopaths. Continuing. Moreover, as explained in Miss Reed's opening brief, the court could have alternatively, quote, A, informed the jury that it could not be required to continue deliberations without its consent, and still, B, asked it to retire to consider whether it was prepared to return any partial verdict, end quote, provides the case law. So again, it's like, why does the defense have to provide these alternatives? Why does the defense have to make all of these badass, solid arguments in rebuttal to Judge Bev's bullshit and the prosecution's bullshit? Why is not the prosecution and Judge Bev, why are they not citing alternatives? Why are they not at the very least saying, you know what? You're absolutely right. The Tui Rodriguez charge was not an alternative to a mistrial. You know what, defense? You are absolutely right. Like, we were supposed to seek alternatives, and we did not. We really fucked up. Right? Like, no, like, neither of them are doing that. The prosecution's not doing that. Judge Beverly Cannoni's not doing that. And yet, if either of those groups of psychopaths had any integrity, they would at least own their failure to follow case law, their failure to follow court rules, their failure to seek alternatives before declaring a mistrial. Okay, continuing. The Commonwealth does not respond to the defense argument on this point. Yeah, the prosecution did not respond to the defense. Like I said, this is the defense saying, by the way, the prosecution in their reply brief did not actually respond to this argument. And I already said that when I read the prosecution's reply brief. They don't actually respond to the defense. They provide rebuttal and new arguments. Continuing. The Commonwealth cites no authority for its suggestion that an opportunity to be heard after the jury had been discharged is somehow sufficient to support manifest necessity. Fuentes suggests such after-the-fact opportunity is not sufficient, in parentheses, observing that, quote, the more prudent course would have been to consult with counsel, end quote, before declaring mistrial, notwithstanding that court gave the parties an opportunity to be heard, quote, after the jury were dismissed, end quote. The Commonwealth's contention that Miss Reed consented to the mistrial is based on the unsupported assertion that, quote, defense counsel consistently sought a mistrial, end quote. It bears repeating that neither Miss Reed nor her counsel ever requested a mistrial. Yeah, if anything, the pulling away guys from the document, like, again, the prosecution and Judge Bev both swear up and down that the defense wanted the mistrial, but nowhere in the record did the defense request a mistrial. Nowhere on the record was the defense or the prosecution given an opportunity to comment about the mistrial before the mistrial was declared. I agree with the defense. It bears repeating that neither Miss Reed nor her counsel ever requested a mistrial. Continuing, instead, by requesting a Tui Rodriguez charge, counsel indicated that they wanted the jury to be instructed to try to reach a verdict rather than consenting to the ordeal and risks of a second trial. The defense argued that Miss Reed's personal consent was required at the Superior Court hearing on her motion to dismiss. Counsel stated that after the final jury note, quote, there was no opportunity for trial counsel to speak to Miss Reed. After all, it's her rights, not just theirs. The defense contends that this was sufficient to preserve the argument that Miss Reed's personal consent was required. At the very least, it was sufficient to preserve the contention that, quote, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. And the Commonwealth does not suggest otherwise. Good job, guys. Number 2. The jury's unanimous conclusion following the trial that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. For more than a century, binding case law has warned against the exaltation of form over substance in determining what constitutes an acquittal for double jeopardy purposes, provides case law. In parentheses, quote, however, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense, end quote. While many of these cases have arisen in the context of judicial acquittals, the Commonwealth does not explain why form should outweigh substance with respect to jury acquittals. Indeed, quote, the double jeopardy clause prohibits re-examination of a court decreed acquittal to the same extent it prohibits re-examination of an acquittal by jury verdict, provides case law. The Supreme Court has, for example, quote, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether that acquittal is express or implied by a conviction on a lesser included offense, end quote, provides case law. Despite the defense repeatedly pointing out the absence of contrary authority, the Commonwealth still cites no, quote, case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because a final unanimous agreement was not announced in open court, end quote. Really good, guys. I'm going to read that again. They're saying the prosecution cited no case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because a final unanimous agreement was not announced in open court. So it's like the defense is saying, the prosecution and Judge Bev, they keep arguing that because the verdicts were not announced in open court, there were no verdicts, but they provide no case law. The defense is saying they're saying all that shit, but they're not proving it. They don't got the receipts. Where's the case law? They provide no case law to support their argument. The fact that there were actual verdicts is not it's like just because the verdicts were not announced in open court does not mean that they were not verdicts. They are still verdicts in the eyes of the law, in the eyes of case law, established case law. It's like, as long as there are verdicts, whether or not they are announced in open court, those verdicts prevent re-prosecution. But again, if you listen to the prosecution and if you listen to Judge Bev, they lie. They just fucking lie. Like, well, the verdicts were not announced in open court, so they're not verdicts. They're not actual verdicts because they weren't announced in open court. It's such bullshit. And again, the ACLUM amicus brief also goes into this, that actually the verdicts are verdicts whether or not they are announced in open court. Continuing, in parentheses, affirming correction of verdict on one count after, quote, receiving a telephone call from two of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit. Okay, continuing in parentheses, affirming changing verdict on count where, quote, post-verdict interviews of several jurors determined that the jury had intended to acquit. Provides case law. Bluford and A. Juvenile both turned on lack of finality, not form. Continuing, the foreperson's report prior to the end of deliberations lacked the finality necessary to amount to an acquittal, quite apart from any requirement that a formal verdict be returned or judgment entered, end quote. There is no serious question here regarding finality. The affidavits, all based on post-trial statements, reflect a clear and unambiguous decision that Miss Reed is not guilty. This is not a case like Bluford where the jury continued deliberations after allegedly reaching a verdict. And there is simply nothing tentative or conditional about the jurors' post-trial statements. In parentheses, juror B texting, quote, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him, end quote. Intermediary C, relaying juror C's statement that there was, quote, no consideration for murder too, end quote. In parentheses, quote, juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote. In parentheses, Juror D, quote, Juror D explained that the jury reached not guilty verdicts on count 1 and 3. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3, because that's what happened, end quote. In parentheses, quote, Juror E stated that she decided to contact me to provide information about the results of the jury's decision-making following deliberations. Juror E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges, end quote. The foregoing was corroborated by 2 voicemails received by the prosecutor stating, quote, it is true what has come out recently about the jury being unanimous on charges 1 and 3, end quote. One juror expressly stated that the agreement persisted after the jury was discharged. In parentheses, quote, Juror D explained that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Question mark. In these circumstances, the Commonwealth's unsupported suggestion that jurors may have changed their minds is purely hypothetical. The post-trial affidavits are more than sufficient to entitle the defense to an evidentiary hearing. Succinct argument, as usual. The defense is on it. They are on it. It's an A game, and again, they're covering every angle here. This is like a chess game, and they've got all their powerful pieces, and they are carefully moving them all forward. And I'm sorry, Judge Bev, she's about to be checkmated. The prosecution is about to be checkmated. And I'm saying that, praying that the Supreme Court has some integrity. It's clear that nobody in Norfolk County has integrity. It's clear that that Judge Beverly Cannoni, it's clear that she does not have integrity. And it's clear that the prosecution does not have any integrity. Just like the law enforcement people who so-called investigated John O'Keefe's death, they didn't have integrity. You know, I'm saying, guys, like Karen Reed is surrounded by people who want to put her in prison, and every single one of those individuals lacks integrity. They are all shady as fuck. I will make a part 2, and I will upload it as soon as possible. Thank you for watching.